Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 Fiancee visa, and we're also discussing tourist visas. There are certain circumstances where an individual will have been issued a B1, B2, or just simply a B2 tourist visa, or even a B1 visa in the past. A non-immigrant visa, best colloquially described as a tourist visa, where an individual will have a tourist visa for the United States, but they'll want to go ahead and seek a K-1 fiancé visa in order to be processed into the United States and marry their fiancé therein and go ahead and adjust status to lawful permanent residence. But the question arises, is it possible to travel into the country using a tourist visa while this K-1 fiancé visa is currently pending? While it's on file with either the Department of Homeland Security's USCIS or the Department of State, is it possible to use the tourist visa, sort of simultaneously, for lack of a better term? First, quick sort of overview on the intentions inherent in the K-1 fiancé visa. As noted in a previous video on this channel, it is what some would call a dual intent visa insofar as it's a non-immigrant visa where the applicant is allowed to have immigrant intent. And in fact, the applicant for a K-1 visa is denoting their intentions specifically with respect to immigrating to the United States, which makes traveling into the United States on a tourist visa somewhat problematic, as the tourist visa or the holder of a tourist visa and the entrant into the United States needs to go ahead and have non-immigrant intent at the time that they travel into the U.S. This is going to come down to very, very circumstantial, to the circumstances of a given case, is what I should say. So what we're basically saying here is there's going to be some circumstances where this is heavily not advisable. There's going to be some circumstances where the matter might be a little bit gray, and sort of trying to understand it may require perhaps a little teasing. And then there may be some circumstances where it's perfectly warranted, because the individual may only need to be traveling into the U.S. for a very brief period of time, and they intend to go ahead and continue processing their immigrant case abroad. What I recommend under the circumstances of one or a couple who are sort of wrestling with this problem, contact a legal professional, as the circumstances of a given case are going to dictate what actions to take. Because traveling into the United States on a tourist visa, you have to signify non-immigrant intent. And if those intentions are blurred, or immigrant intent really does exist or could exist within that trip, that's a real problem. That could be fraud, misrepresentation, or a finding of inadmissibility as an intending immigrant without proper documentation could be made. So for those reasons, it's probably a good idea to contact a legal professional if this situation has arisen, in order to get a better idea of where one stands with respect to how the provisions of each type of visa actually operate, in order to understand how they specifically interact with the facts of the given case.